Okay, so Tony, you ready? Tony, you there? Tony, are you ready? Tony,
I'm ready. I'm having trouble unmuting. I'm ready.
it's okay. Let's go on the record on cause number DC 194598, Weimer versus Sadagian. Counsel, make your appearances.
Gene Dubose for the plaintiff.
Shabazz Nizami for the defendants.
Could you spell your name just so the court reporter will have it?
It's Shabaz. Last name is spelled Nizami.
Let's go ahead and proceed. We're here on a motion to strike.
Your Honor, this motion to strike is fairly simple. The counterclaim that was interposed is all it is the defense of our affirmative declaratory claims. And the law on that's pretty clear. That's not an appropriate use of a declaratory judgment. So that should be stricken.
Okay, response.
Judge, that's actually not true. The counterclaim is actually an action for quiet title, and it's more than just it's not just a mere denial. It's actually an affirmative relief. We're asking for the court to declare a recording that was filed in Dallas County back in April of 2019, filed by the plaintiff. We're asking the court to null and void that and declare that as invalid. And so the counterclaim is it's not a denial of the plaintiff's claims because it's independent of that. And to give a hypothetical, in the instance if plaintiff non-suits all of their claims, our counterclaim is still valid and it's not contingent upon the claims asserted by the plaintiff in this lawsuit. So our counterclaims will still proceed forward in that case. And so that in and of itself should be indicative that it's not just a mere denial, it's actually a claim for affirmative relief. And so based off that, we're asking the court to deny the plaintiff's motion to strike the counterclaim.
May I respond, Your Honor?
Sure.
He says that he wants to strike the document. That document and its validity is one of our affirmative claims. So, you know, it may be that if we dismissed everything, this would be a good claim, but we haven't and do not intend to dismiss everything. There's nothing in their request for declaratory judgment that is more than what we're asking. They're saying quiet title, we're saying established title. So it's just a reflection of what we have affirmatively sought and should be struck.
Judge, if I may respond.
Sure.
The recording that plaintiff's counsel is referring to is already on file with the Dallas County records. I believe we've already have that on file with the court. So that recording in and of itself, it's still there. There's my clients have a right of cause of action against that, the validity of that recording. And it's not contingent upon the claims or asserted by the plaintiff in this lawsuit. That is a separate matter. And so whether we proceed in this case or in a separate matter, my clients have a right of cause of action to seek affirmative relief based on the validity of that recording that's currently on file with Dallas County Property Records Office.
And again, if I may respond, that document is one of the basis of our claims. We're saying that it is valid. He's saying that it isn't valid and is a cloud on the title. That's just denying what we're asserting.
I will say this. I think this is one, it's probably premature, but two, the way I've always dealt with these types of things is via summary judgment. And so I don't know that I necessarily agree that it's a mere reflection. And usually either I deal with these in summary judgment or more often I do this in trial. So I'm not going to strike the counterclaim at this point. Is there anything else we need to chat about?
Yes, we have two other motions. One is
motion to reopen discovery.
Yeah, and that's not really reopen discovery. We served discovery on each other many months ago. They served requests for admissions, and we served a request for disclosure. And we answered their request for admissions, and they did not respond to our request for disclosure. When we were conferring on this motion, opposing counsel said that if they had not responded yet to the request for disclosure, they would do so as soon as possible. I mean, it's not opening all discovery, but just all we want to do is get an answer to the request for disclosure.
Judge, if I may respond.
Uh-huh.
We have no objections, obviously, to responding to the request for disclosures, and we can give it an explicit date as to when we'll respond. So there's no issue with that. The issue that I have is I'm not opposed to open discovery, and the basis for that is because plaintiff has filed 2 supplemental petitions recently asserting additional causes of action. And so if the court is going to allow the plaintiff to proceed on those additional causes of action, then it just makes sense to reopen discovery so that we can conduct discovery on those additional causes of action and then address the merits of it later down the road in a summary judgment or a trial, whatever the case may be. And so I do think that if we're going to allow those supplemental petitions to proceed, we have to reopen discovery so that we can, do discovery on those causes of action.
If I may respond, that's not my motion. My motion is just to get an answer to the request for disclosure. It seems to me that if defendants want to reopen discovery, they need to make a motion on that.
I agree. Though I will tell you, just to avoid another hearing, that if you have, and it looks like you also have a motion for continuance, is that right?
Yes, we've agreed that since there are no jury trials, I have to actually be in the hospital with my wife that day. It seems to me, I had been assuming when my wife scheduled that this was going to be sort of automatically continued because of the limit on jury trials. And then when I got a notice from the court coordinator to appear in court, I said, I better get a motion on file so I don't have to be there. And there's been now a new order, a couple days ago on jury trials, which apparently there are jury trials taking place and they're trying to figure out how this all works. But I don't think it's in your court, is it, Judge?
No, we haven't done any jury trials yet. I don't foresee we'll do any anytime soon. When do you want to reset this to?
I would think, when do you think jury trials are likely to start again? If you,
let me say the one thing that I'm moderately confident of, which is we're not going to have any in October for sure. I would say I'm 99% confident of that, unless somebody does kind of a one-off. My guess it will be sometime next year. What my current intention is I'm resetting most cases to next year and kind of giving this admonition, which is if we're not back to in-person jury trials, then I'm going to be looking seriously at doing Zoom jury trials, which nobody wants, including me. But if we're going to be without jury trials for 9 months, I've got to do something. And so if I reset this, just be aware that there's a chance you may be going to a Zoom trial if that's where we are. Now, obviously, if we can avoid that, I'll do everything possible to avoid that, but we've just got to do something.
Well, I've sent a proposed order in. It's got a blank space on it, and I figure.
Well, you tell me what you'd like. What would be a good day for you?
I'd like it, if we're going to next year, I'd like to have it in January. It's been sitting around for a while.
Okay. January sounds okay to me. What about opposing counsel?
I have no objections to that, Your Honor.
So Rhonda, can you check it for me? How does, we have January 5th, 12th, 19th, and 26th.
Are they all jury dates, Judge?
I don't think we're going to have any non-jury weeks next year because of what's going on. So I've been talking with Judge Moore, who's our presiding judge who puts that together. And she's told me that at least her inclination is at this point to not have, other than like Christmas, not to have any, and maybe Thanksgiving, not to have really any non-jury weeks. But we'll see. I mean, things are fluid. So I don't know, but I would say we're probably somewhat safer to try to do this in, you know, late January, but I have no idea.
That's fine with me, Judge.
Want to do
No, no,
January 26th?
that's fine, Judge.
Well, January 2nd and 9th are not specially set yet, so you might want to go with them, actually. You want to do the 9th?
9th would
Yes.
be better. January 2nd, that's a rough day to have a trial.
I agree. That's too close to it. I don't know that we even can get juries then anyway, so the 9th is probably better. Okay, well, and do we cover everything you guys needed?
For now,
Yeah,
Your Honor, yes.
I think so. So are you, will you, will opposing counsel agree on a date when I will get my request for disclosure? Because,
I would say within 2 weeks.
okay, well, I've got an order, I think with a blank time and on, I just filed. a bunch
So
of-
can you do this? Email my court coordinator, fill in the blank time, put the date of this hearing on the beginning. So on this day, put this date, like on August 10th, I consider the following, and then fill in the date for when the disclosures are due. Also email Rhonda a continuance order that has the January 9th date. And finally, if you could go ahead and send me an order denying the motion to strike. Just send all three of those orders to Rhonda.
Okay, I'll do the granteds, and Shabazz, I'm assuming you will do the deny. Yes?
That's correct. That is correct.
Okay,
Perfect.
and we'll copy each other on them in case we have any problems with it.
Well, Mr. DeBose, I hope your wife is okay. And
It's routine stuff that, stuff that she needs to have done. And she seems to be pretty healthy. She is, she hasn't lost her capacity to disdain her husband, which I think is always a sign of a healthy wife. She tells me that that's her job, to keep me in line. And she's in the next room and she can hear me, and I will.
She's
trust
probably, I
me.
can't believe you said that to the judge.
Yeah, she can. She knows me.
How long have y'all been married?
We have been married 14 years and a couple of weeks. Matter of fact, did you know, every anniversary, there's a silver and the gold and all that. The 14th is the frog anniversary. And I gave her 2 sculptured frogs for it.
That is very romantic.
Oh,
I don't keep track of that.
well, I'm really looking for, I think the 18th is the badger. And a little badger goes a long way. Anyway, Judge.
Anyway, great to see
pleasure
you
to see-
guys. You guys
Yeah.
be safe, and we'll get these things reset. Just get me the orders, okay?
Okay.
Thank you,
All right,
Judge.
thank
Take
you,
care.
Glad to
guys.
see you, Judge. Bye now.
Take care.
See you.
Bye-bye.
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 Well, let's see. Are we off of YouTube?